Sakshi TV's special immigration show with attorney Ms. Sheela Murthy from Murthy Law Firm. Please note that Sakshi TV now has 3 immigration shows every week: on Tuesday at 3 p.m. EST with attorney Ms. Sheela Murthy, Wednesday at 5:30 p.m. EST with attorney Prashanti Reddy in English, and on Friday at 6 p.m. EST with attorney Bhanu Ilindra. Please tune in to ask your questions. If you're an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information provided on this show is not a legal advice and is for general informational purposes only. Sakshi TV or its agents will not be responsible for use of information. If you need specific legal advice, please contact the attorney directly. Ms. Murthy needs no introduction, but if you need consultation, please log on to murthy.com and take Sakshi's name when you actually contact them. From the beginning, murthy.com has put a wealth of free information and online tools in the hands of immigrant community and for the benefit of US employers. The murthy.com site provides you with latest and cutting-edge information on the US immigration law and policies explained in terms you don't have to be a lawyer to understand. Today's topic is the I-140 FAQs. We will continue the knowledge session along with the Q&A from last week, and before we get into the topic, you can call us on the numbers displayed on the screen for questions related to immigration and also ask for tips. Hello Ms. Murthy, how are you doing?
Hi, good afternoon to you, attorney, and to all of our viewers of Sakshi TV. I'm honored and delighted as always to be here with each of you.
And so are we, Ms. Murthy. It's an honor to host you. So Ms. Murthy, before we jump into the topic, do we have any latest immigration updates this week?
So there's nothing that's latest other than the fact that the president just issued the proclamation clarifying on October 25th, clarifying that November 8th, which is less than a week away, that the people who are entering the United States are no longer required the national interest exemption in order to enter the United States, that they can simply show proof of their vaccination status that is acceptable either by the World Health Organization or the Centers for Disease Control, which is part of the U.S. Department of Health and Human Services. And as long as you can show that and a negative test, then the airline should be allowed to board you, and U.S. law should permit people so that no longer the 33 or 34 countries that were subject to the prohibitions, including India, which is on that list, would now be subject as long as that the individual can show that they have complied with the required vaccinations and the negative test. And that is effective from November 8th of 2021. So that was like the main thing that just got released. And I think we talked a lot about the US Department of State visa bulletins last time because that had just been released also. So I think we're pretty much up to date at this point, Thorni.
Right, Ms. Murthy, I'm sure we are. So let's get straight into the topic then. Since we're discussing I-140 FAQs, I thought I'd start with the most basic question. What is an I-140 and how does one file it?
Sure. So the I-140 is an immigrant petition for the employee who is a foreign national worker, right? So what does that mean? That means that this is the stage where if the labor certification has already been filed and the employer then decides that, okay, now I have shown the Department of Labor that there is no available, ready, willing, or able worker to do the job. Now I, the employer, need to satisfy the requirement that I have the financial ability to pay the required prevailing wage to that foreign national worker to work on a full-time and permanent basis with my business or company or LLC or S Corp or whatever the entity or the organization is. And the employee, the foreign national, needs to show that the person has all of the qualifications and requirements as listed on the PERM labor certification process to show that that person is capable of getting the I-140 petition approved. Now, generally, I-140 requires an employer and an employee, though there are a couple of exceptions. For example, those filing in EB-1A, or the extraordinary ability, or EB-2, national interest waiver petitions, which can be both of them can be self-sponsored, so you don't need an employer. In that case, the priority date for the I-140 petition is determined when the I-140 petition is filed, not like in a PERM case, where it is the date of the filing of the PERM, with the US Department of Labor that determines the person's priority date, which, of course, as we know, is extremely valuable and important for people, especially from countries like India, where, if you have an earlier priority date, obviously you're going to get the green card within a matter of years and years, but certainly not like majority of the countries where EB2 is current almost all the time, except for China and India in the employment category. They can get their green card within 2 or 3 years, whereas for Indians it could take 5 or 10 or even 15 years sometimes to get the green card. So that's in short a very simple overview of what is an I-140 immigrant petition for alien worker.
Right.
Thank you.
Right. So, Ms. Murthy, we have a caller on hold, Mr. Vijay Singh from Pennsylvania. Thank you for calling, Vijay. You may ask Ms. Murthy your question directly.
Hi, good afternoon, ma'am. I'm Vijay Singh. I'm starting with a bad question. I don't know how do you take it. This is regarding the arrest records. So, does USCIS consider the original arrest charges or the convicted charges?
So the USCIS,
this is regarding a shoplifting charge, like the original charge.
The USCIS requires the person to provide both the charging document, the original charges, and the final disposition or how the court or the judge ruled on the case, Vijay. So you have to provide the charges, but they cannot consider that ultimately, because it's ultimately what happened to the charges. A lot of people have very, very serious charges, but then based on the evidence or based on the facts or after a jury trial or without a jury trial, ultimately it is up to what the final court disposition that will determine whether the person is eligible for the green card or is considered inadmissible because you have such a serious either felony or multiple misdemeanors not associated with the same incident that makes a person not eligible for admission or to become a permanent resident of the United States. So it's always the final disposition, Vijay. So if you are having very serious charges, sometimes, for example, there are prohibitions on domestic violence, very strict prohibitions. So if it's changed to, for example, assault or battery, but it's considered a smaller issue. So immigration with any criminal issues becomes extremely complicated because you don't just have federal immigration law that comes into play, Vijay, but you also have state law components because in the United States, every state has its own separate criminal laws. And so under each state criminal statute, you have to look at the definition of what is, for example, driving while intoxicated, what is simple assault, what is simple battery, and it can vary from state to state to state. So you may have a friend who had the exact same situation in the neighboring state that may have had no problem getting a green card, but somebody else in a state right next door might end up causing the person not to get the permanent, the 485 approved or the immigrant visa issued at the US consular post abroad because the particular criminal offense is considered an inadmissible offense unless you can get a waiver. You have to file the immigrant visa waiver, and that's usually based on having an immediate family member and showing extreme and unusual hardship by being forced to return back to the home country. So criminal issues are an extremely complicated factor to take into account. And I would venture to guess that more than 9 out of 10 immigration lawyers are not capable of analyzing and dissecting the state criminal statute with the federal criminal statute, because you need a state criminal lawyer and somebody who understands federal immigration laws in order to be able to determine the level of risk that the person, whoever has this unfortunate criminal situation happen in their lives. I hope that was helpful for you, Vijay.
Right. So, Ms. Murthy, we have another caller on hold, Mr. Santosh from Chicago. Thank you for calling, Santosh. You may ask Ms. Murthy your question directly.
Hey, ma'am. My name is Santosh. Actually, I have a question like, I have approved I-131 and 765 has been approved. And my questions are like, can I travel to India and come back to US on advance payroll without visa stamping and want to continue on my H-1B? And another thing is like my wife I-765 and 131 still pending with USCIS. So if I travel alone on my advance payroll, so if is my wife's status be, I mean, out of status because I'm only converting the advance payroll, or I don't know, but that is my question, sir. Can you please advise on this?
Okay. So there's a lot of gray area on some of these issues because there is no actual statute or law or there's not even regulations on this topic. There are just legal USCIS memos and discussions through the American Immigration Lawyers Association, or AILA, with senior government officials of the USCIS right from the time that the AC-21, the American Competitiveness in the 21st Century Act, or AC-21 law, was passed. So, is it safe? In general, because H-1B and L-1 enjoy what's called the benefit of the doctrine of dual intent, a person is allowed to maintain H-1B status and also have the green card case filed, the 485 filed and continuously pending. So in a situation like the example that you gave, you would be allowed potentially to travel abroad, re-enter using the advance parole without taking the risk of getting delayed or stuck at the US consulate, but you won't be admitted back into the US. The word is paroled. You would be paroled back into the United States and not admitted as a non-immigrant on the H-1B status. However, USCIS has stated almost 20 years ago that in a situation where a person re-enters on the advance parole, if the person continues to work for that same H-1B employer, right? That same employer, then before it expires, if the employer and the employee both wish to renew and discuss renewal or extension of the H-1, then that is permissible for the H-1 to be extended, even if the person chose to enter on the advance parole. And dependent family members' H-4 status can also be renewed in that situation. So in theory, based on USCIS policy guidance and what they have said verbally, it should be possible for a person to travel and come back. Now, some lawyers say, well, we don't want to take the risk, or the company attorney may hesitate to allow that, or they may not be familiar with all of the different nuances because it is, as I said earlier, not mentioned in the actual statute or law or in a regulation, but it is more policy issues. So it's possible the employer may dissuade it or they may refuse to file an H-1 extension in the future, saying you already have an advance parole and EAD and we don't want to waste money, thousands of dollars filing an H-1B extension for you. And it should still be okay because you have an H-1B and the spouse is allowed to be on H-4. And until the EAD and AP for your spouse, for your wife, is approved, potentially she could continue to stay in the US because she's considered in a POAS, period of authorized stay, based on the 485 filing. And when the EAD is approved, she's certainly allowed to work. And if she gets the advance parole similar to what you are planning to do, she could potentially travel abroad and return back as well. Good luck. I hope that was helpful for you.
Right. So, Ms. Murthy, moving on to our next I-140 FAQs. My next question is premium processing available for I-140? And also, if can a person request for premium processing while their I-140 is pending?
Yes. Thank you, Tharani. So the law does allow the premium processing for I-140 petitions. And it is possible to file it under regular and then later upgrade it by completing the form and submitting the additional fees that the USCIS requires to do their job within a reasonable period of time. But where the situation is that sometimes when they're overwhelmed, the USCIS says, sorry, we're not willing to do premium processing in certain situations where we're overwhelmed. So that's a risk that you could take if you wait too long. And in some cases, like happened with a lot of the EB2 to EB3 downgrades last October and November of 2020, the USCIS refused to allow premium processing of many of those downgrade petitions. Why? You may wonder. It's because by law, the policy of the USCIS is that they have to have the original underlying perm with them in order to approve and accept the premium processing of the I-140 petition so that they can verify that it is legitimate and bona fide. Hence, in many of the downgrade cases, the original was already with the USCIS, maybe with a different service center, so they were unwilling to do the premium processing. But if it was with the same service center, you can certainly, even if they reject or deny the premium processing request, saying the original perm is not attached to this premium processing request, the employer can respond saying that, in fact, the original perm is in your particular service center, hence you should be allowed to. And that's what we have seen in a majority of the cases, that if the perm is in the same service center, they have access to it, they can verify it electronically, and then they will approve it under the premium processing program.
Right.
Thank you.
So, Ms. Murthy, moving on to the next question, is there something a petitioner can do to ensure that their form I-140 is not rejected by USCIS?
So rejected is a different meaning than what we use it loosely in India. Rejection means that the mailroom returns back and rejects the package for failure to include, for example, the correct filing fee, the correct check, signing the check, putting the correct date on the check. Because if a check is more than 3 or 6 months old, they have the right not to accept it and to send back the package. And the problem with rejection is sometimes it takes them 2 or 3 or 4 months to open the mail, check it, issue it, and then return it. And by that time, if the priority date has retrogressed or gone backwards, then you're out of luck and you cannot file the 485. So rejection is different than, I think what you want to ask, Thorny, is could it be denied? And denial also requires a serious, so everything is in the details, everything. So if there's even a small typo with the check amount not matching to what you have written on the check, then the USCIS will return and reject the package, and the case could get denied, and the person may be out of luck if the priority dates go backwards, like what has happened right now in the month of November, what has started effective as of today, right? So you have to be very, very careful. Dot all the I's, cross all the T's, look at the checks, look at the forms, look at the underlying documents, look at the qualifications, ensure that the person is qualified if it's a perm-based job with everything required under the perm laws, and confirm that you have all the attached documents, the employer's tax returns regarding financial ability to pay, the individual's degree certificates, documents, proof of the prior experience with the work experience letters. Every single thing has to match exactly what was the minimum required under the perm in order for the person to be able to be qualified to get that I-140 petition approved.
Right.
Thank you.
So that was very elaborate, Ms. Murthy. And what happens if an incorrect visa category is selected in the part 2 of the form I-140?
So depends. Sometimes they will look at it as a typo and approve it in the correct category. And sometimes they will say, reject the entire package, saying you checked the wrong box. If you catch it before they make a decision and say, look, we caught this, please correct it. It was a clear error. It was a typo. If it's before they make a decision, they could correct it without charging an additional fee. But if they decide to deny it, and again, the dates retrogress or roll backwards, then again, that could be a problem in that case, even though it could end up costing double the filing fees to pay for the I-140 petition processing twice. It may be better for the petitioner, the employer, and the employee to file a fresh I-140 petition, check the correct box, and to ensure that it is accepted and not rejected in the mailroom of the USCIS, and hopefully actually gets approved, because all of the information that is required for the I-140 approval is in fact included with the I-140 petition so that it can be processed and approved in a prompt and timely manner. Of course, we know the USCIS is not processing almost any case nowadays in a prompt and timely manner.
Right. Ms. Murthy, please correct me if I'm wrong, but can this situation not be, can USCIS not dispose it as probably an RFE?
So they could. That's why I said in some cases it depends on the particular officer or examiner, or if they feel like it was truly some kind of a error. In some cases, we have seen people are lucky to get RFEs. In some cases, they get the rejection. In some cases, they get a denial after it is processed for 6 months, 8 months, 1 year. And if you're worried that the priority dates will go backward, backwards, then that is exactly why you need to ensure by checking off that or filing a new EB in the correct category and sending it in before the priority dates retrogress or go backwards, because that would be far more risky for both the employer and the employee, especially the H1 is getting expiring and the employer doesn't want to file another H1 extension because it costs so much money to process an H1 and go through all of the hoops and the filing fees and the legal fees and the processing fees and the lawyer fees, etc. So yes, they could issue it as an RFE, but we have seen cases where they have, and we have seen cases where it's been denied or rejected in the mailroom, which is the third option.
Right. Right. So also, can the petitioner request consideration of multiple visa categories in the form I-140, Ms. Murthy?
So you're saying checking off multiple different visa categories. So you have to pick what do you want, employment based first preference, second preference, third preference. And for each separate classification, you have to attach the underlying documents which match with that. So if I check off 3 different forms, then they will get either confused or deny all of it, because you have each classification has its separate underlying documents or requirements. And there's no option which says this or this. So if you do an EB2, you do an EB2, and later if you downgrade, you do an EB3. We don't do it as an amendment, we do it as a separate new filing. So that way we have both the EB2 and the EB3 options available for the particular employee, to make sure that we can have the benefit of either one if the priority dates change. But again, a lot of people were told don't try to upgrade again unless the final action dates are current, because again, if for some reason thousands of people try to again upgrade back and that date goes backward, then again you'll have to file again a new petition. So you can monitor it, and those who are getting approval, great. Or if you don't mind interfiling the new the old previously approved EB2, then it becomes an EB2 case, and that's how you need to proceed with it.
Right.
Thank you.
So, can a petition be withdrawn, Ms. Murthy? Also, if yes, how can one request the withdrawal of their I-140?
So any filing, whether it is a petition or an application, can absolutely be revoked or withdrawn by the party filing the petition. So if it's an I-140, the petitioner, as we know, is the employer. The employer sends a letter to the USCIS saying, I hereby wish to withdraw the I-140 petition based on the fact that the employee is no longer working for me, or we no longer wish to proceed with the EB2 classification, or whatever the reason. Or you don't have to give a reason. You can just say, I wish to withdraw it. And the USCIS will send it. By law, there is sometimes what we have seen is the employer by mistake has withdrawn the wrong I-140 petition for the wrong employee. Many times that has happened. Or they've withdrawn a different petition, they withdrew by mistake the EB2 instead of the EB3, or whatever mistake they made. But there is no prohibition under the law where you can withdraw a withdrawal request. Because once the USCIS accepts that withdrawal and agrees and withdraws the I-140 petition in this example, then you cannot say, whoops, I made a mistake, please don't withdraw the other one because I made a mistake for this other employee. Sorry, you're now going to have to file a fresh case for both employee 1 and employee 2 because of the negligence of either the employer/petitioner or the employer's attorney or law firm involved with the process.
Right. So, Ms. Murthy, how can one apply for an adjustment of status after their I-140 is approved?
So actually, a person doesn't even have to wait for the I-140 approval in order to file the I-485 adjustment of status. It is very possible to file the I-140 immigrant petition concurrently or simultaneously with the I-485 adjustment of status application if the date of filing or the final action date shows that the filing is permissible in a particular month. And then the USCIS cannot approve the I-485 until the final action date shows that it is current for the particular month in which they approve it. So yes, it is certainly possible to wait till it's approved in case you're worried that, for example, in highly discretionary cases like the extraordinary ability or the national interest waiver, sometimes people don't want to file the 485 and waste more filing fees in case the I-140 doesn't get approved. But sometimes people are desperate to go ahead and actually get the approval, or at least to get the EAD card while the 485 is being processed, in case they're not eligible for H-1B or H-4 EAD or whatever the reason that the person is filing both these cases.
Right.
Thank you.
Right. So, Ms. Murthy, what if a self-petitioned I-140 got approved while their I-485 is still pending? Can they leave their current job?
So remember, green card is always based on the concept of a future job offer. It is never based on the current job. H-1 approval allows a person to work for the current employer, the H or the L or the other non-immigrant status. It is what is the person's future intentions. So as long as the person can show that they plan to work for this particular employer in the future, doing that particular job, or file the 485 with the employer, if it's based on an NIW self-petition case, then they would need to show that they're performing that same job duties and that same particular benefit, which is in the national interest of the United States, in order to file the 485 based on their own self-petitioned NIW by porting an earlier priority date based on an employer or perm-based case. It is certainly possible, as long as all of the I's are dotted, the T's are crossed, and proof of every possible and showing how there's prospective national benefit to the United States by having that particular person, whether it's an extraordinary ability or national interest waiver, both have to meet the legal requirement of prospective national benefit as required under the law.
Right, right. Thank you, Ms. Murthy. With that, we come to the end of the show, and this is my favorite part because this is that time of the show that you give us a very special takeaway, and not just the viewers, but even I learned something from it every single week. So, what is your golden immigration message this week?
Okay, my golden immigration message, as with life, is continue to feel a sense of hope and gratitude. This month, of course, is Thanksgiving month, and Thanksgiving is all about being thankful and showing gratitude and appreciation for whatever we have in life. Yes, it is extremely stressful to go through the immigration process. We have all gone through it. U.S. government and the Department of Homeland Security and USCIS don't make the process simple or easy, but you have succeeded in your life till today, graduated college, done so many things in your life. Continue to work hard, stay focused, and have a sense of attitude of gratitude, because the attitude of gratitude will always give us a sense of positivity and positive energy that will give us fuel for success in our lives. With that, I want to wish all of you a really wonderful afternoon. Take care, stay safe, and stay healthy. Thank you, Thorny, and thank you to Sakshi TV.
It was a privilege hosting you. Thank you. You're watching Sakshi TV Live with me, Torani Makana. Thank you.